All right, so our agenda today is going to cover three things in an hour, and I'm going to try to make it as interesting as possible. Are there any lawyers in the room, first of all? I don't have any friendlies in the audience. Okay, all right, so we're going to do this. So I'm going to try to make what can be a very dry topic as interesting as possible, and I'm going to try to use real life examples because I think that's the easiest way, because I could talk about the Florida statutes and you'd be asleep instantly. But if I say, this is why we do this, and this is why I think it's always easier. So the first item I want to do is say, what are the essential actions that you have to take when you lose a loved one? And there are some things which are absolutely critical, and there are some things which I honestly think have been invented by Google, and so everybody has their Google law degree, as we say, right? And so they go online, it says, well, it says I had to do this, this, and this, and I'm like, yeah, but if you look at this, what it says at the bottom, that would be if you lived in California, but since you live in Florida, you don't have to do this, this, and this, right? And so I would say this, there isn't anything that you have to do absolutely right away. And I just used that word absolutely. Isn't that weird? He kind of put that in my mind. But so the way I tell everybody is that when there's a loss, focus on the loss. That's really all you have to, you should be focusing on yourself, on your family, on your children. Deal with your grief, because there isn't anything legally that I have to do within the first couple hours of a death, right? Because we have to wait until there's a death certificate, first of all, because I really can't even accept you as a client until you can prove to me that the person is deceased. And I'm sure this will be hard for you to understand, but I did have one child come to me once and lie about the parent's death. And so here I was saying, well, I'm just, very sorry for your loss. And of course, I just started down the path of a death. And then I get a call from the daughter who says, did my brother just call you? And I said, yes, he did. And I'm very sorry about your father's death. And he said, well, he's not dead. I'm like, that's interesting, because he just told me he was dead. He said, no, he parked him in a nursing home up in Tampa and didn't tell us where he was. I'm like, well, that's the essence of evil right there, I would say, right? So anyways, like I said, that, until you have the death certificate, there really isn't anything that I can actually do legally anyways. So I would say all you really have to do, if you're a client of ours, or if you're calling us, if you just say, I lost my spouse, and again, I'll say, okay, at this stage, there really isn't much I can do for you other than once you have a death certificate, call us back, and then we can proceed. And so what that first appointment should feel like with the attorney is we're going to try to understand, A, was there a will, right? Because obviously that's going to drive what happens after that. And if there's not a will, that's not the end of the world either. All that means is that they're intestate, right? So if you ever hear that phrase intestate, and I'm also going to try to do my best to use a vocabulary. And so like if I say a word, and I can tell just by looking at your eyes, like, well, what did he just say? I'll try to explain that word. And so testate, with a T, is when you die with a will. Intestate is when you die without a will. It's that simple. If you die with a will, and that is your last will and testament, that's the one that, we as a court system are going to follow. And then if there's somebody else who says, no, that's not the last one, they did one just before they died. Well, I'm going to say, okay, well then let me see what that one says, right? Because that one could be perfectly valid also, and it served to revoke what I thought an hour ago was the last one, right? And so we have to be able to figure out what is the last one, and is it valid, right? Because we're always on guard for evil. And so there is what we call undue influence, where a caregiver could talk that person into saying, I've been here for you for the last 3 years. I've been doing everything for you. I'd really, I would appreciate something from you. And then suddenly there's a new will where the caregiver's included. And of course, just because the caregiver's included, doesn't automatically say that it was fraudulently obtained, but it's one of those things which is going to get our, it's going to get our spidey senses going, and we'll just say, okay, well, let's see if there's anything else, that is inappropriate in there. And so with the will, again, that drives everything. And so as long as there isn't anybody who's going to contest it, which again, I would say happens in the movies way more often than in the real world. Because if you're going to contest a will, it's only really going to be on the grounds of incapacity. And that means you have to prove that the time that person signed that document, they were not of sound mind. And that's not impossible to do, but it is hard because you have to be able to have a doctor who says is that they were under my care, and one day prior to that, I declared them as incapacitated. And so, in my professional opinion, there isn't any way possible on that day that person would have comprehended that document. And so if you can obtain that kind of evidence, well, then you could legitimately challenge the document. The other one, as I said before earlier, is what we call undue influence. That's where we have to, say, would this person have actually done this on their own? And if not, well, then undue influence had to play some role, right? However, that goes before the judge, and then we have to just weigh the evidence as we always do, right? But in Florida, what we have are called Carpenter factors. That was a case that we refer to all the time. And there's certain factors which if you can prove that, and I'll use both of you as an example. So let's say that you passed away, and then I'm going to ask and say, okay, well, she now is the sole recipient of everything. Even though for the past 40 years, he had everything going to you. So I'm going to be interested to say, okay, well, did she make the appointment at the attorney? Did she drive him to the attorney's office? Was she present at the discussion? Was she present at the signing? And if I'm able to show that those factors exist, I can create what we call a presumption of undue influence. And that's pretty powerful in the law, right? Because it's a shifting of the burden. So all I have to do is to say, well, look, I can say is that she was involved in the process, and now the onus is on her to prove to the judge why it was not undue influence. And so again, I don't want you to think that's every case, but it can happen, right? So the moral of all of that is if you're going to do your own will, I always say, there's going to be far more scrutiny of that document. Just because, and if you have people who are actually in the document as your witnesses, it's going to be even further scrutinized. And if you were to do a will for somebody else, because you're a frustrated lawyer and you say, well, I just did my own, I'll do yours, it's going to be, again, scrutinized as to why did you do that, right? So I would just, and this is where, so as an attorney, I'm biased, but I would say it is worth your money to hire an attorney. Just because of the image, right, of the optics. And actually you say, well, I went to this attorney that I had zero previous relationship with, and I said, this is what I want, and you should be the only person that is meeting with that attorney, they should not allow your child in the room or basically anybody else in the room, right? And then you should just say, this is what I want, and that's exactly what will be in the document. That way, should someone challenge your document, I can say, I don't have any issue with it because she came alone, she told me what she wanted, and that's what we did, right? So it's very critical, I would say, is that when you're gonna do those documents, use an attorney, and don't be surprised when your a companion or whoever brought you to the appointment is asked to wait in the waiting room, right? So the other one I wanted to also touch on, which we see a lot of, is that when you do your will, you want the original, which is like a piece of gold, to be secure. Because, and you have to think about this, is that because if you have a will and say, these are your children, and you cut him out, and he gets to your house first, and he looks at the will and says, well, look at that, I'm cut out, we're not gonna have this, and so he destroys the will. Now you die, what do you call that again when you don't have a will? Intestate. Intestate, good, you pay attention, all right, I love it. So then you die intestate, which means that it would go automatically equally to the children. And so now he's back in, right? Just by destroying your will.
Can I have one question on that?
Sure.
Wouldn't it be filed at the courthouse?
Nope. While you're alive, it's not. While you're alive, no, it isn't. Is when you die, we have 10 days to deposit the original. But if I don't have the original, or I never even met you before, then I don't know what you had. All I know is he comes to my office and he says, you're dead, and she never had a will. And so the importance of the will is that you have to store it somewhere secure, particularly when you're cutting somebody out, right? Because obviously they have an incentive to destroy that document, right? So the other thing I was going to say too is that when you do have and again, I want to be respectful of time, but as you can probably understand, there are trusts also, right? Which are other ways of planning. And a trust is really, it's just an entity, the way I describe it. And it's a vehicle that you can put assets into. But even when you have a trust, you should have a will, right? Because it's called a pour over. And all it does is it says, should I have an asset that I forgot about, and it was only in my name when I died, and it didn't have beneficiaries named on it, I want those assets to pour over to the trust. So the trust is ultimately the controlling document when you die. And it's going to have, what we call the dispositive instructions, which is the who gets what. That'll be in the trust. And that trust is always private, right? Which is the other interesting thing, is that everyone says, well, that my will is private. And I said, wrong answer. Once you die, I deposit it. It's in the public domain. And so any neighbor who's nosy about what you had in your will, they can go online, go to ClerkNet, type your name in, and there's your will. So if you have anything that you don't want the world to know about, like you cut out your son, you'd want to do that in a trust, right? Because when you have a trust, the will just, all it says is, I leave everything to my trust. Very boring document to read. There isn't anything juicy in there, right? But the trust is going to have all the colorful language, right? Is that he's a drug addict, and that's why that he's never, and again, anything that you want to put in there that you don't want the world to know about, that's where we put it. Yep. So the other thing I want to make sure people understand also, because this is something that I see all the time, is that if you have a power of attorney document, which I should have asked this question early on, I forgot because it's Saturday. So of everybody here, how many of you already have your estate planning in order? Almost everybody, okay. You need homework and he needs homework, okay. But anyways, and so power of attorney, as you probably understand, those powers are only alive while you're alive. When you die, those powers are gone. And even while you're alive, when you have a trust and your assets are in the trust, that power of attorney document doesn't give your agent, as we call it, any power to act on your trust, right? And so I'll have people, well, they'll call my office and they'll say that my mom has a trust, I'm her power of attorney. I'm like, well, that was a wrong answer, right? Because that doesn't mean that this, I can't even talk to you about that, right? But if you said to me, you're the trustee of the trust, and you show me evidence of that, well, then you're welcomed into my office, right? And so, a lot of times when your children or your loved ones are your agent through the power of attorney document, but they're not your trustee, they don't get to talk about your trust, right? And that's the one thing I would add too, is that, so I think is that we live in a time in which parents are obviously transparent with their children. I would say actually quite a bit greater than when I was a child. And so I think what is happening is parents are actually sharing these confidential documents with their children prior to their death. Then they're changing them, but the child isn't I guess, always aware of that. So I've had this happen a lot, where the child will come to me and say, well, this is the trust. And I'll look at it and go, it was 8 years ago. You're absolutely right. However, it's been, like 4 times amended. And so the latest version doesn't look anything like that, And so it's one of those things where I honestly say that it's your prerogative, because obviously these are your documents. But I would say, why not keep them confidential until you die, right? Just because you could change them. I would say powers of attorney and healthcare documents obviously should be shared immediately, because I think, as you understand, those powers are live immediately. And so, for that person that you trust to put in the document, obviously, they need to know that they have that job. Because the other thing, that occasionally happens is that we'll get a call from somebody and they'll say that my mom had a stroke, she's incapacitated, and I'll say, okay, well, I just have to look at at her documents, and it will say, okay, well, her sister is power of attorney. And so I will call that person and I'll say, this is who I am and this is what I need you to do. And they're like, I never asked for that job. I'm like, okay, well, she thought that you would do the job, and so I have you in here. And they say, well, I can't do it. And I say, okay, well, then I have to see who the backup is. And so then I'll have to go to the next person and I'll say, how about you? And they're like, I never asked for that job. And so you want to make sure that whoever that you choose for these jobs, that you've already talked to them and that, they acknowledge that, right? Because this is what I find interesting is that, the majority of us will lose capacity before we die. It's just how it is. I mean, we are all living longer. Dementia is absolutely everywhere. And I would say is that there's a pretty high, I shouldn't say all of us, but I would say that there's a pretty high probability is that all of us will live long enough. And so what we will have, it would be called a diminished capacity. That's all it really is. Or it could be a mild cognitive impairment, you could call it, right? So I don't want you all to think, as I believe, is that we're all going to die of Alzheimer's or something like that. But I'm just saying is that we have to prepare for incapacity as important, as we prepare for death. Is that because we see so much incapacity in our practice, it's unbelievable. And if you've already lost capacity and you don't, in other words, already have a power of attorney in place or a healthcare directive, our only option as society is a guardianship. And guardianship, I would argue, should be totally avoided, right? And I do those all the time. And so it's one of those things where, I despise them, but but it's the only option, right? And so the easiest way to avoid guardianship is to have a really good power of attorney, really good healthcare directives, and I would also argue, and a trust for your real estate, right? Just because quite often we find is that if you have your house in your name only and you die, it is going to go through probate, right? Because I think we understand is that, in other words, even with a will doesn't avoid probate. A will just tells the world where you want your stuff to go when you don't have a trust, right? And so the only things that will pass automatically are like your tangible items, which are like your clothing, furniture, jewelry, cars, right? Those can pass per the will. But if you own any real estate, if you have bank accounts, if you have IRA, 401k, insurance, all those items, you either have to own them jointly or with somebody else, or you have to have beneficiaries on them, right? So it's one of those things where, and you want to make sure, I would argue, that you have a primary and a contingent, right? Is because I see it happen all the time. If the only beneficiary is just one person, and if that one should predecease you or die with you, well, then we're back to probate again, right? And so it's always smart to say, well, okay, so my primary will be this person, and my contingent will be this charity or whatever you want. Because again, it's what we call, good beneficiary housekeeping is the way I look at it, right? And so once a year, once every 2 years, however often that you feel compelled to do it, I would say what you ought to do is just look at basically all your assets. And then, and you have to play the game of, what if I died tomorrow, right? And that's where you got to look at it and say, okay, well, this one says if I die tomorrow, then it all goes to her. If she survives me, if she doesn't survive me, it all goes to him. And then if you have a trust, well, then you could title that asset unto your trust, or you could have the trust as the beneficiary of the asset, right? Either scenario will avoid probate. So let me think about the other things I wanted to hit on real quick. So the other thing, which is also, which I see now here a lot, is if you have a partner but it is not your spouse, then it becomes even, I would say, more important that these documents, particularly the healthcare documents, are important. And the scenario is this, and I have had this probably a couple times a year, right? And that your partner is in the hospital, and you are the primary caregiver. And so, for the last 10 years, while their child was estranged, it was up to you. And then now they're hospitalized, and according, to the Florida statute, which we call the proxy, it says is that there's a hierarchy, right? And so a guardian is at the top of the list, and then it's a spouse, then it's a child, and then it's some other blood relative, and then a friend is all the way over here. And so when you're not married, what are you? You are a friend, right? And so that's one of those things where people say, yes, I'm just a friend, but I've also been his primary caregiver for like, the last 10 years. And now this child who hasn't been around at all is going to trump you at the hospital, right? They're going to walk in and say, well, I'm his child, I'm in charge now. And I've had a lot of people call me and say, this is absolutely horrible. I'm like, it is, but it is, and it is what it is. And so the easy way to avoid that is that you name your partner in the document as your surrogate for healthcare, then they're going to call the shots. It's not going to be your child, right? Okay. Or it's going to be, again, in the order that you put them down. So the other thing I wanted to discuss also with healthcare, because this is common. So you have what we call a living will. Living will is not what you think of as your last will and testament. Last will and testament is really only even relevant when you die, right? A living will is the document in which you say that I do not want to be kept alive. I don't want to be on a ventilator. I don't want to have a feeding tube. And so it becomes critical is that you as the person, you have already put that in writing, and it's been properly witnessed, because that is the document that the medical professionals are bound to follow, right? When you don't have that at all, as you all know, they're required to keep you alive. That is their job, right? And so the other thing which is interesting is that if you have that, a lot of us will always say, well, what about a DNR, which you've all have heard of that as well. And so the do not resuscitate order, that doesn't have anything to do with you being kept alive or not. That document, as I'm sure you already understand, all that says is that should your heart stop on its own, we won't take any action. That's all it says. And and that applies with you sitting here. So if all of a sudden she had a heart attack right now and I saw her drop and I went over to her and said, hey, I know how to do this, but then I see on her wrist she has a thing that says a DNR. Legally, she doesn't want us to do anything. And so our job is to say, well, we're just going to, obviously keep her comfortable, but that's all we're going to do. And so when you're in a hospital, should you decide that if you say, I don't want to actually be resuscitated, you've got to request that. You have to say that that's what I want. Florida allows your health care surrogate to do it for you. And so as a couple, let's just say is that you made a pact and you said, if I'm ever 85 and I don't even recognize who you are or who anybody is, and I'm miserable, well, then I want you to put that in place for me, right? But the other thing about a living will is that you can, there's actually 3 categories in there. One is called the persistent vegetative state. The other one is called the end stage condition, and the other one is called the terminal condition. And all that really says is if you are in either of those 3 scenarios, and your primary care doctor plus a second doctor come to the same conclusion, which that there isn't any reasonable probability of your recovery, you do not want them to take those extra actions. And so what's important here for all to understand is that your health care surrogate doesn't, in other words, get to override that. They don't get a vote in that, right? It's because you've defined it. And so the way that it should work is that, those physicians, when they come to that conclusion, they should be calling your loved ones and saying, okay, so now she's at this point where she said she doesn't want us to actually do anything else. And so we're going to honor that. And all that means is that, they'll keep you pain-free, obviously, but there isn't going to be any heroic actions taken at that point. So did anybody have any questions? Yes, ma'am.
So my husband passed away, so basically I have myself. We never had children. We did have foreign exchange students that we call our children. They live in Germany. So if I wanted to make one of them a surrogate, they're already part of our will and trust. And I don't know if it didn't really matter once the two of us were still alive because we were each other's.
Yep.
And then them.
Yep.
Does that bring into problems because they live in Germany or
Nope.
anything? Okay.
Nope, that doesn't have an issue
All right, cool.
whatsoever. This is, but what one thing that I did want to say though, which what you just asked, I was thinking through, was that, so with your will, that role that you're naming in there is what we call the personal representative. And it's what Florida calls the executor. So if you hear that word there, synonymous. That role in Florida, that has to be either your blood relative or the spouse of your blood relative, or they have to be a Florida resident. And so you can't have like your sorority sister from Ohio, right? Because that she won't qualify here, right? But if she decided to actually to move here, because she's smart just like all of us, well, then she qualifies immediately, right? But that's the only role where we have that requirement. All the other jobs, all they have to be is 18 and of sound mind. Yep.
If I was listening to you right, like the house, bank accounts, if you do not put a beneficiary on it, it will automatically go to probate even if you have a will and a trust.
Correct.
So as a beneficiary for the house, for all the bank accounts, refer to the trust, so in turn, the trust can then distribute it without probate.
Correct, that's right. And so for that scenario to actually play out, that house would have had to have already been titled into the while you're alive. Right, yes, okay. And then the other thing which I'll add is, okay, yep.
The house has to be entitled to the trust?
Yes.
Or is the house being in my name, do I have to put beneficiary, or do I have to change the house into the trust?
So you can't put beneficiaries on a house.
Okay, I didn't know.
Right, that's the thing, yeah, that's what I say. But Florida does give us an option, which a lot of you might have already heard this. It's called a ladybird deed. It was actually named after Lady Bird Johnson, who predates me, but I understand is that she was the president's wife. And the way that I was explained was that the first, I guess, attorney who actually created this, as an example, he just used that name, and it stuck. And so what that deed is that you actually deed the property from yourself back to yourself for your lifetime, and you put on there what's called the remainderment, which that can be just one person. So like if you said, I don't have children, but I have one nephew, I love him like a child. So if you said, I want the house to be his automatically when I die, that type of a deed would accomplish it. And that while you're alive, you control the house. And so he doesn't have any vested ownership interest while you're alive. However, when you die, we record your death certificate, and the title then will just automatically shift into his name.
One more question.
Yep.
So if you deed the house to the trust,
That's right.
do you lose your homestead exemption?
No.
Because it's in a different name.
Well, it's not really in a different name though, because it's still basically in your trust, which is still your property.
But you said you changed the deed, okay.
Yes.
But, thank you.
Yep.
So you said you deed the property back to yourself.
That's, again, when you don't have a trust, and if you said, and this is the way, this is one of those areas where if you asked 5 attorneys, I bet you'd probably get 5 answers, but I'm the only one here, so you're only going to get the answer that I give. So here's the answer I give. It's always easier to do that if you just have one person receiving it, right? Just because it's easy, because one person can't argue with anybody else. I guess if they want to argue with them, with themselves, that's up to them, but they can't argue with anybody else. But if you've got, let's say, 4 children, and you say, well, I want to do that kind of a deed, and I want the title to go to the 4 kids automatically, then I have to ask you all kinds of questions. I have to ask, do the 4 children like each other, right? Because if you say, oh no, they don't talk to each other, then I'm going to say, well, then what you're going to create is horrible, right? Because you're going to be forcing joint ownership of a piece of property onto 4 people who can't agree on the color of the sky, and now they have to own this house, and the taxes are due. And they all look at each other and say, well, I don't want to pay the taxes because I never wanted to own this anyways, right? And so I always say that you can use it when there are that scenario, but I would usually say that it's always easier to do it if you're just only going to have one person inheriting it, right? And then the other thing that can go wrong with that deed is if the remainderman, like we said for her would be him, if he should predecease her, well, then the deed won't work anymore, right? And so then I have to have her come back in, and we have to do a new deed, right? And say, well, I know you wanted it to end up with him, but he's gone now, and so I need to know, is there anybody else that you want, right? Yes, sir.
And could you put your children on your deed before you die?
Yes, that's also, you can always add them on as a joint owner. However, you need to understand though what that means, right? Because if you add them on as a joint owner, then it isn't your house anymore. It's basically all of your houses. And so if all of a sudden you decide to say, you know what, I'd like to sell the house, well, they have to agree to that. First of all, if they say, yeah, no, I don't want to sell the house, well, then you're screwed, right? Or when you sell the house, at the closing, you're like, okay, well, I get all the money. Like, no, you don't get all the money. We have to give you the share. We have to give them a share. So then, because when you make them an actual owner, that's what they are. They're an actual owner, right? That's why I don't ever recommend that you would put your child on as a joint owner of your bank account. Right? Is because once you do that, even if it was all of your money, which is in there, once you put them on as an owner, they have the right to actually withdraw all of the money, even though they didn't actually put a penny in there. They can just walk into the bank and say, "I'm an owner of this account. I'd like to withdraw all of it." And they don't have to call you and say, hey, Fred, your daughter's here and she just withdrew the money. Because it's not your money, it's basically your money, all of you together, right? That's why I don't recommend that. I also don't recommend that is just because if your child were to cause a car accident, or if they were to IRS issues or anything like that, what was your protected asset alone is now exposed, right? And if I were going to be suing your child, I'm looking for every asset with their name on it, right? So I definitely don't recommend that. I would say that if you have an account and you say, I want this account to automatically, go to my 4 children when I die, then you just have to put the 4 of them as what they will call either payable on death, or transfer on death, and that's something that, again, I would say it should be a requirement at the banks. However, it's not, right? And so I've had this happen over and over again where my poor client, I would think, honestly, is that, if you were to lose a spouse, the bank should be required to tell you to say, okay, look, you have this huge probate exposure right now. So if I were you, I would say choose somebody else now that you would want to get this account when you die. And that's the kind of thing where they don't do that. And so, almost always, all of our probates involve an account that was formerly owned by 2 spouses. One died, and the survivor wasn't given any guidance at the bank. Yes, ma'am.
Comment, this probably wouldn't happen today, but my mother had an older will, and there was 4 of us children, and my sister predated her by 3 weeks when she passed away. And so there wasn't a cesspurdy, what is?
Per stirpes.
Yeah, I'm not saying it
That's
correctly,
okay.
but, so my sister's portion had to go into probate because she didn't, there was an older will and she didn't have that, so just in case.
Yeah, so I think I understand what you're asking, but I think I want to just clarify a little bit.
Statement.
Yeah, but I want to make sure you understand. So in other words, when you have in your will, let's just say that you say, I leave it to my 3 children, and then you have this comma, and then it says per stirpes, which is that it's just a Latin word, but all that says is that if your child predeceases you, their share will go automatically to their children equally. When you don't have it in there, then it will just stay in the pot and get split up with the others that are in the pot. And so that doesn't cause probate to happen. All it means is that it'll actually be distributed differently, is the way I would look at it. However, when your child survives you, even if it's only by a day, and then they die, well then there isn't any way that you can control what happens at that point, right? Because they survived you, they took all the assets, right? And then it's then going to go per their will, right? And so, like the most common trust amendment I get asked for is what I affectionately, called the evil daughter-in-law, or basically evil son-in-law protection plan. And all it is that, when my clients will come to me and they'll say, our daughter has just gotten married, she loves him, we do not. And so we do not want our assets to all go to her, and then if she dies, shortly, they're all going to go to him. And I'm like, well, that's what will happen, right? Because she survived you, and now they all belong to her, and it's going to go wherever she wants it to be. And then they say to me, I don't want that to ever happen. And I said, well, what do you want to happen? They say, if she dies even after us, we want it all to go to our grandson only. Then the only way that we're able to do that is that we can't leave it all to your daughter directly. So what we have to do is say, it's going to be held in trust for your daughter. And so she can actually utilize it. But when she dies, if there's anything left over, it isn't going to the evil husband. It's only going to go to the child, right? And so that's just one of the things where if you want to go home today and you want to read your documents, you have to just go through there and say, well, okay, what would happen if I died tomorrow? And you can connect the dots and say, okay, well, if I died tomorrow, it says everything will go here. I'm okay with that. And then if that person died right after me, it's all going to go here. I'm okay with that, right? But if you say yes to here, but then you say, oh, hell no to here, well, then you have to change something, right? All right, so the other thing that I wanted to just briefly touch on within 5 minutes, and then I'll be happy to answer anything else anybody has. So a guardianship is what I was saying to you earlier. I want to make sure that you have the facts on guardianship, just because the press and everybody else, so there's urban legend out there, which I have to say is just, again, it's like a telephone game where all of a sudden, I tell him, he kind of understands what I said, but then he explains it to her, and then she explains it to you, and then when you explain it to her, it's basically all jumbled up at that point, right? So here's the way I want you to all think about this, is that guardianship is a last resort, always. And so our judges here and so it's a probate court, right? And so, their job is to say, are there any other alternatives to guardianship? So that means is that if you have the valid power of attorney and you have the valid healthcare directives, well, those are what we call less restrictive alternatives to guardianship. And so just by having those in place, you will theoretically avoid guardianship, unless those people that you appointed are the evildoers, right? And so like if we discover, that your agent that you obviously trusted at one point in time, they're now the person exploiting you, and you've lost capacity. Well, then, the way I look at this is that as society, it's like we have to protect you. And so the only way that we can protect you is with a guardianship. And it's because you've lost the capacity to then say, okay, well, now if it isn't her going to do it, I'd like it to be her, right? I mean, that would be great if I was able to ask you that. But typically, whenever I ask you anything, all you look at me is like, say, well, I don't even know what you're asking me, right? So it's one of those things where you are a definition of a vulnerable adult, and you deserve to be protected in that way. And so should a person file for a guardianship over you, what's going to happen is that, and again, so it can be anybody. So your neighbor could see you acting strange and say, I think there's something, whatever. So they can file, it'll be actually 2 court actions simultaneously. There'll be a petition to determine your incapacity. That will trigger automatically, our court will appoint an examining committee. That will be 3 professionals that will come out to your house, and they'll examine you. They'll give you cognitive exams, and then they'll write reports. Those reports are filed at the courthouse, and then there's a hearing. And at the hearing, what the judge's job is that based on the opinions of the experts, are you incapacitated completely or just partially? And what they do is they go through all these rights and they say, should you retain the right to vote? Should you retain the right to drive a car? And it goes on and on and on. The other thing that happens automatically is the court will appoint an attorney for you, just to be sure that your due process rights are respected. And so, but here's the one thing I want you all to realize: all of the costs, so the petitioning attorney, the court-appointed attorney, all those examiners, all of the court costs, everything is going to come out of your pocket if a guardian is appointed over you. And that's when people are like, well, why would I have to pay? Because it wasn't as if I brought this on. And I say, it's just the law, right? And so it says that the ward, which is the person that is under guardianship, is financially liable for the entire cost of that action. So the easiest way to avoid it, again, is to have a real good power of attorney, real good healthcare surrogate. And I would also add with the trust, just because when the property is in a trust and you lose capacity, your successor trustee is in charge, right? So that's what I would have to say. And I'd be happy to answer anything anybody else would like to ask you. Yes, ma'am.
So if you have a trust and a will made in another state, and you live here now,
Yep.
you need to have it changed a bit to fit
Great question. Yes.
Florida law?
So here's what I would say is that a foreign will, which is basically what we call anything which isn't from Florida, is still going to be valid here. However, as long as it was executed validly by the laws of where you came from, right? However, like I said though earlier, is if the state where you came from said that your sorority sister could qualify, she won't qualify here, right? And so it's one of those things is that it'll still be valid, but there could be elements of it that will be overturned a little bit, right? And then as far as the other thing, which is interesting though too, is that I personally believe that you should update the will just because the first sentence of it always says, I, state your name, right? A resident of, you want that to say Florida. And why that's important is that because if you happen to be from Pennsylvania, where there's taxes like crazy, you don't want there to be any confusion that when you die, are you a Florida resident or anyplace else, right? Because if you died there, you are still, I think you all understand this, even if you're a Florida resident and your summer home is up there, should you die there, your death certificate, in other words, will be that state, but you want to make sure 100% that it says resident Florida, right? Because if it says resident there, their tax man is going to say, well, this is how much you have to pay us, right? So you want to make sure of that. With the trust, what you should do, I would say, is you should basically update that section of the trust which says this trust, shall be governed by. That should say Florida law. Yeah. But as far as the actual trustees, that doesn't change anything. Yep. And I would say too, for everybody, is that powers of attorney, test them, right? That's the easiest thing to do, because like if you say, well, the only one that I have is an Ohio one, I would say, well, if she's named as your agent, let her go to Truist and say, this is what I have, would you approve this document? And if they say yes, absolutely, then you're set. If they say no, well, then what you should do is then get a Florida one. Yeah. The only other thing I was going to add about that too is that there are powers of attorney that we see all the time that are usually drafted either at home with like LegalZoom or any one of those, or your friend who is a real estate attorney who says, oh, you want a power of attorney? Sure, I have one of those for you right here. Here you go, right? What the problem is on all of those, again, is that as we age, quite frequently, they don't have all of the powers that you want your agent to have. And really what becomes important is that like a Medicaid planning, for example, you want your agent to be empowered to do the planning that's required to make you eligible for Medicaid. And a really homemade power of attorney would rarely have that in there. All it would say is that you can sell my car if you want to actually do all these things. You can do that. But they're always, I would say, I shouldn't say always, but the majority are lacking, is what I would say. So that's why I was again, as an attorney, I'm biased, but I would say, it's always better to pay for it. And, then you put the onus on me, in other words, to get it correct, because if I don't, well, then I have a big malpractice policy out there, which you can go after. Whereas if all of a sudden that you do the document for her and it doesn't work the way she wanted it to work, right? Then her children are asking me, well, what the hell is wrong with this thing? I'm like, well, her neighbor prepared it, and so this is what you get, right? I guess on the positive side, it was free, but the negative side is that it just doesn't work, right? And if you had already lost capacity, I can't correct it for you. And so then I have a guardianship on my hands, right? And it was all because of that just, one document was declared to be ineffective.
It happens.
Happens all the time. All the time. Yep. Anything else? Anybody else? I've completely bored you to the point you have no more questions. Excellent. Well, thank you very much. Thanks for having me.